right, we're going to get started on the webinar today. So this is employees. Do you have proper agreements in place? And I'm Sarah Holmes from Holmes Business Law PC. And so just quickly, for people that don't know us, we are a business law firm. I myself have been a business owner for a number of years outside my law firm and now with a law firm. We provide general counsel services to mostly smaller businesses and some medium-sized businesses. So things like incorporation, employment agreements, trademarks, and contracts. Most of what we do ends up being contractual in nature. And the reason we started this is because when I started my first business, I really struggled to find someone to help me with some legal issues. And it was at that time, not a lot of people focused on this market. There were, free legal services, and then there were big firms, but there was nobody really looking out for the smaller business owners and providing help. So that's what we do now. We have a team in place where we're able to help our contracts with general counsel services is how we describe it. So generally, if a legal issue comes into your business, you can contact us. If it's something that requires a specialist, such as maybe litigation or, excuse me, sometimes people have patent questions. We have people we can refer you to for more specialized business legal services. But otherwise, today, we are talking about employees and employment, how to make sure you have the right agreements in place, the right type of compliance. So right now, we're going to talk about compliance. And when we talk about employees, I just want to make sure that everybody's on the same page. We are not talking about independent contractors or 1099 people that you might be using in your business. A lot of people use that interchangeably. They refer to their contractors as employees. Legally, that's a really bad thing to do. You don't want to do that. Specifically, your 1099 contractors are not employees. They're 1099 contractors that you have under hopefully a proper 1099 agreement. So we are not talking about those kinds of people today. We're not talking about 1099 contractors. So if that's mostly who you have, a lot of this discussion is likely not going to apply to your situation. Now, for people that do have W-2 employees, quite frankly, a lot of what we talk about today is the reason why people don't want to have W-2 employees, because there's a lot of compliance, there can be a lot of paperwork, there's a lot of legal issues you need to pay attention to, but there's also a lot of upsides to having W-2 employees, meaning you can have people that really help your business. They have some type of loyalty to you and your company. They have a vested interest in helping you. And you're creating more stability for your employee. So there are definitely positive reasons to have employees. A lot of people think that W-2 employees are much more expensive than a 1099. That doesn't have to be true. You can have part-time people, you can have seasonal people, you can have occasional people. Those can all be W-2 employees. You just have to make sure that you have the proper compliance in place. So when we talk about employment compliance, one of the main things that comes up, which is always our initial discussion with people that are hiring or reviewing employees, are wage and hour laws. Now, there's wage and hour laws on both the federal level and the state level. And these laws specify what you need to pay someone at a minimum level, whether you need to pay them overtime. Sometimes the law tells you how often you have to pay them or how consistently you have to pay them, and things of that nature. So we get people that come to us and, they say, well, I just want to pay this person a percentage of the business they bring in, or I want to pay them, a fraction of the amount of time they spend with this client. We get that a lot with our therapist and like medical professional clients. And the thing is, like, unless you're really tallying up how often that person's working for you and the hours that they're working, you don't know whether this kind of alternative compensation structure is really compliant with wage and hour laws, because it does still have to meet minimum thresholds. Now, there have been a number of minimum wage increases set to take hold in Pennsylvania soon over the next year and a half. So you always have to be cognizant of that if you have any type of employees that you're paying on a lower wage scale. Overtime is also a big issue that's been in the news in the past couple of years. They have changed a lot of the classifications for people that would, in prior years, likely have been exempt from overtime, where those thresholds now are different, plus the minimum amount of money that you need to be paying someone a salary in order for them to be exempt from overtime has changed. So if you have any people that have been on a salary, they work more than 40 hours a week, they're not necessarily in a managerial capacity for you, it might be time to look at how you're compensating them and just make sure that you don't owe them overtime, because a lot of people, I think, incorrectly assume that just because you're paying someone a salary means that they're not, you don't have to pay them overtime, they're exempt. That's not true. That's not the test for that. So anyone you're paying a salary, anyone that's not managerial, or I suppose we could say professional in nature, meaning like you own a medical practice, you're hiring other doctors. I mean, regular sort of employees, you're paying a salary, they're working routinely over 40 hours. Make sure that you don't owe them overtime. There's big class action lawsuits that come out regarding overtime quite frequently. There's been some really high profile corporations that have been nabbed for overtime. And the penalties are pretty severe. So always make sure that you're compliant with wage and hour laws, including minimum wage, including overtime, and including how you pay people. So that would be number one. Number two would be safety. So safety can be a lot of things. Safety wasn't really an issue for most companies we deal with until COVID came out. And now there's a lot of issues around safety, but safety in the workplace is often governed by OSHA. There's certain, rules around workplace safety, how to report incidents in the workplace, workers' compensation claims. If you run sort of what I'll call a white collar business, it's mostly office work, people sitting at their desks. Usually, the biggest types of claims are things like carpal tunnel syndrome, repetitive movement type injuries by clients. So you want to make sure people have good workstations, they're safe, they're set up properly. With people working from home, that's really difficult. But as the employer, you still have some potential responsibility for that. So you want to make sure your employees still have a safe place to work. They're using equipment that ideally you've given them. Like a lot of people have employees use their personal equipment for a number of reasons. That's always not the best way to do things, largely for security reasons. But, if you are issuing equipment to employees, you want to kind of inquire about their work setup and what they're doing and make sure that that's in a good place. Now for COVID, this has, been a huge thing that we've been dealing with for people, such as, do they feel safe in your workplace? What are the precautions you're taking among your other staff? What kinds of procedures do you have in place if you have members of the public or clients coming in and interacting with staff? So you definitely want to have some type of safety plan in place around COVID. At the end of the presentation, we'll talk more about COVID and vaccination and things that you could be doing. But last year, when all this happened, we helped a lot of people get COVID policies in place for their employees. So if you haven't done that yet, you certainly want to make sure you do that now. Maybe your workforce has been remote for the last year and you're thinking about bringing people back soon. So definitely before you bring people back into the office or back to the workplace, you want to have that type of stuff in place so that they feel safe. Now, FMLA, that is a federal law that doesn't kick in until you have a certain number threshold of employees. Usually it's 50. And that's dealing around sick time, offering leave to employees. And a lot of people don't quite fall under that threshold. But what they neglect to realize is that there are certain jurisdictions that have their own sick time rules. And the biggest one in this area that people generally know about is the City of Philadelphia sick time law. So that provides that any employer has to provide sick time to its employees. And the sick time has to be worded in a particular way. It has to be tracked in a particular way, excuse me, in terms of how the employees accrue the sick time. It doesn't necessarily have to be paid. It depends on how many employees you have. But sick time laws are generally something that you always want to be cognizant about and make sure that you're compliant with, and always be checking in on any updates. And then finally, there's discrimination laws. So, Pennsylvania by default, if you're in Pennsylvania and not New Jersey, although both are by default an at-will employment state, meaning that you can fire any of your employees for any reason or no reason, as long as it's not discriminatory and as long as you don't have them under an employment contract that states otherwise. This is why most people don't use employment contracts, because they want the ability to hire and fire people at will. So again, the key language though is you can fire people as long as it's not discriminatory. And quite frequently what is discriminatory is expanded upon. So, things like race, national origin, religion, those are clear markers, right? But in, the last few years, there are cities and places that have adopted more classes that could be considered discrimination. LGBTQ, sometimes, the transgender, I think, is coming up more. So those eventually might be added as more classes for potential discrimination cases. The biggest area where we see discrimination claims, certainly race can come up a lot. The second way would be disability claims, ADA claims, because that is just a wide open field. If you have an employee that comes to you stating maybe they have trouble hearing, right? And they need you to buy them a special kind of phone to do their job, that's potentially an ADA claim. This employee has told you they have a medical condition, they might need some kind of accommodation, but otherwise they can do their job. If you don't handle that type of situation properly, that can lead to an ADA claim. And ADA, again, is Americans with Disabilities Act. And potentially, if you were to take action against that person because of their medical condition, that can lead to a retaliation and discrimination claim. And you also have to be careful. You'll find out later in the COVID questions, you have to be careful what exactly you're asking employees about. You really shouldn't be asking employees a whole lot of medical questions. If they want to come to you and disclose that voluntarily because they need something to do their job, then that's fine. And then you can ask them questions to clarify and to try to help them, and especially help them get an accommodation. But otherwise, you really should not be discussing medical conditions, health conditions, anything like that with your employees generally in the workplace. All right, the next thing is you generally want to have some kind of employment agreements in place with your employees. Now, I just told you in the last slide that we don't generally want people under employment contracts. These are not an employment contract, by the way I'm referring to it. If I say an employment contract, I mean, this is a contract with the employee that states you're going to work for me for 3 years. I'm going to pay you $50,000 a year. You can't quit and I can't fire you unless I've discovered you're embezzling money or, you're showing up drunk, something like that. That's, in my mind, really an employment contract. It's locking this person down. They have to work for you for a certain amount of time. This is what you're going to pay them. They can't quit. And these are the only reasons you can fire them. Okay, so let's just get the terminology, that employment contract. Then we have what I'm going to call employment agreements. These, might be in a contract, but generally these are standalone agreements that we even give to at-will employees and normally suggest for at-will employees. So it's stuff like, number one, a non-compete. And that is typically, if I run a gas station, right? My gas station is in zip code 19123. I'm going to hire you as the manager of my gas station, and I'm going to have you implement all these new things for me. I don't want you going and taking what you created here and using it with a competitor. So I might have you sign a non-compete that says you can't go manage another gas station within 3 miles of zip code 19123 for the next year. So you want to think carefully about what goes in that agreement. Who would you be concerned about your employees leaving and going and working for? If you have competitors in the marketplace, if you know there are companies that lure your types of employees away, maybe they're able to pay them more, they're able to give them some kind of other benefits, they're able to give them more lifestyle perks than a small business owner might be able to afford. A non-compete might be a really good idea in order to say, hey, once you leave here, like, you cannot go somewhere else and do the same job. Now, non-compete always has to be reasonable. We get clients all the time that call us and they're like, I want you to write a non-compete that covers the entire world forever and ever. Well, no, that's not reasonable. You cannot prevent people from working someplace else forever and ever. We have to draw reasonable boundaries. So those boundaries can be things like distance, like how far away from your office do you not want someone going? Now, in the days of remote work, it's very difficult to figure out what would be a reasonable distance. So then we say, are you just concerned about people in your county? Are you just concerned about people in your zip code? Would it be someone in the region? Or is it direct competitors? Like, do you have a list of competitors or even current clients that you specifically would not want this person working for. So you got to figure out what's a reasonable way to narrow that down. It can also be narrowed by time limit. Now, some people will say, I want it 2 years. Well, if it's 2 years, then we have to make sure that distance is pretty small, because 2 years is a long time to prevent someone from working. So we say, okay, is it 6 months? Is it 1 year? Can we get 2 years? Okay, we can get 2 years, but we have to name these specific competitors. So the court's always going to look at the side of the employee, right? The employee, as far as the balance of power goes, is the one that, the courts, and from a policy perspective, they want people to be employed. They want people to have free range to work. And so they're not going to be on the employer's side if they have to narrow one of these down because it's way too broad and it looks like you really restricted somebody from doing something in the future. Then we want a non-disclosure statement, usually. Whatever someone learns about your business while they're working for you, they should not be going around and telling anyone else about any of that other information, particularly things like your client list, who your vendors are, how you do your pricing. Those are all trade secrets and valuable IP, intellectual property, which is stuff that even if they don't go work for a competitor, you don't want people talking about this stuff. You don't want them talking about it with their friends, sharing at a barbecue, posting on social media. Like, why anybody would do that stuff in the first place, I don't know, but they do. Sometimes people learn things about an employer's, personal life, situations going on. Again, you don't want that stuff out there. Your employees should not be disclosing that stuff. It shouldn't be out there. They should be under a non-disclosure agreement where they can't be talking about things that they're learning on the job. And then there's non-solicitation. So non-solicitation is particularly useful when you are employing people to do a key aspect of your business, right? So if you have the kind of business with, I don't know, maybe you have a marketing agency, right? And you have a handful of 5 corporate clients, and you've hired an account manager to work for you, and this person develops marketing campaigns for your corporate clients. Well, one day your marketing manager wants to quit, or your account manager, they want to quit. And actually they have plans to go open their own agency that's essentially going to compete with you. Number one, hopefully that non-compete kicks in. But even more importantly in that situation is the non-solicitation. And that would prevent that employee from soliciting your existing book of clients, so that your employee can't go to corporate client 1 through 5 and start calling them and saying they're going to get a better deal and try to lure business away from you. They can't solicit those people. Also, if your employee wants to leave, they can't take your existing staff with them. Sometimes your existing staff can be more valuable than your clients, right? It takes a long time to find good staff, to train them. You really want to keep good people. So if you have one bad apple that's going to go open a competing business, you don't want them taking all your employees with them. So a non-solicit would prevent them from doing that as well. One thing I didn't list here, though, that's really important, is generally some kind of IP agreement with your employees, an intellectual property agreement, if you have employees creating things for you. So that would be like, in the context of a marketing company, you have employees create marketing campaigns, they're creating marketing collateral. You want to be clear with them that they do not own those things. Your business owns them. So generally in these employment agreements, it's assumed that an employee creates these things on behalf of an employer, and that would be the default by law. But if you do have agreements in place, it would just be best to make that crystal clear and make it say, hey, look, whatever you create while you're working for me belongs to me. Sometimes we have even more restrictive agreements that are useful. This comes up a lot in like the software industry, where it even says stuff you're doing on your own time, but is related to this job or your position, still belongs to us. So for example, this comes a lot in people that work as programmers, right? They're employed during the day for an employer, and at home at night, they think they can go create some more code that's kind of related to what they're doing during the day. And they think that code belongs to them. The answer to that can be not necessarily. That stuff could still belong to the employer. If it's related, if they're using resources, if they're using knowledge or materials or anything else they gained from the employment with you, that could belong to the employer. But it's best to spell this stuff out in these agreements so that later on, there's no misunderstanding. We have people call us all the time. It's employees, and they have these concerns. They say, hey, I signed this agreement with my employer. I want to go develop this in my own time at night. It's kind of what I'm doing during the day. Can I do that? And we'll say, well, what's in the employment agreements that you've signed? And we go and we review their agreements, and we say, okay, here, clearly you can't do this. Maybe you can. Maybe you should wait until you're not working for the employer anymore. Or yes, you can do it as long as it's not related and you're not using the resources, you're not using their time. Because you'd be surprised the number of employees that really, on their own time, they want to be doing other things. And it could be stuff that even competes with your business or is using your business's resources. So again, best practice would be to put that stuff in writing, make sure people are on the same page and know what they can and cannot do. All right, documents. What kind of documents do you want to have with employees? Aside from the stuff I just mentioned, like the agreements, the non-compete, non-solicit, non-disclosure, and IP agreement, if you don't have enough employees to yet have a handbook, you always want to have an offer letter. You got to be thinking, how would this person know what their job is? How would they know when they're supposed to report to work? How would they know what they get paid? How would they know what their benefits are? How would they know what some of our policies are? If you don't have enough employees to have a handbook in place, that information needs to live somewhere, because what's going to happen is if this person does something wrong or isn't doing their job and you want to fire them, you're going to fire them and say, hey, this is for cause. You didn't show up on time. You weren't doing X, Y, and Z. That person's going to go file for unemployment. And they're going to say, hey, I was fired for no fault of my own. You should pay out this unemployment claim. And you as the employer are going to say, no, I fired you for cause. You weren't doing your job. And what's going to happen is you're going to end up in an unemployment hearing with the hearing officer asking you, show me where it says this person needed to show up at 8 o'clock every day. Show me where it says that, they're only entitled to a 1 hour lunch break. Show me where it says they can't be doing X, Y, or Z on the job. And some of it sounds ridiculous and it sounds like common sense, but with employees, documentation is the name of the game. So if you don't have that stuff in a handbook, you at least want to have it in something like an offer letter so that, in the event you do ever get hauled into an unemployment hearing or some type of discrimination claim, something else, you have a place to point to. These were our policies. This is where it said you can't do these things. And this is why I fired you, not this other reason. So that kind of stuff is very important. Now, if you do have enough employees for a handbook, usually we tell people, if you get to about 5 employees, you really want to be thinking about a handbook, because now it's probably at the stage where you've got enough people, you're growing, you might be hiring more people. So for company culture and so that everybody's on the same page, it would probably be best for your company to have a handbook. Now, some people get handbooks from their payroll company or they write one themselves. That's okay, except that you want to make sure that everything is consistent. We've seen people write handbooks themselves or take ones for their payroll companies, and they're voluntarily subjecting themselves to a law that they don't need to subject themselves to because they don't have enough employees to meet the threshold. You don't want to be doing stuff like that. You want to make sure that if you don't have to adhere to things, you're not necessarily voluntarily doing that and setting yourself up for a standard that you don't need to meet yet. The handbook would also be a place to put in any relevant policies, a non-discrimination statement, how you want things to run, what would be typical things that you'd want to be able to fire someone over. If you don't want them posting on social media, like that's something that goes in a handbook. Vacation policies, whether that time is going to be able to be rolled over every year, whether you would pay out vacation time if somebody quits, how often you pay people, all these things could be in the handbook. And a lot of these decisions, you have a pretty wide latitude and discretion over. There are some things that the law will let you decide how you want to do this. There's nothing that says necessarily that you have to pay out unused vacation time when somebody quits. But the minute you have it in writing or it's a policy, then you have to abide by that for all of your employees. So handbook would give you another tool in your arsenal to potentially fend off any employer liability claims, things like discrimination, things like you weren't doing things properly, sexual harassment or any kind of harassment, hostile work environment. The handbook is critical for those types of claims, because often what people will say is this stuff was going on at work. I didn't have anybody to report it to. They didn't have a procedure in place. Right now, it's like a big thing in the beer world. These news stories have come out about hostile work environments at breweries and beer festivals and things like that. Handbook is where it says, look, if you feel that somebody's harassing you at work, if you are made to be uncomfortable, here's our procedure to deal with this. Here's who you talk to. Here's who you report it to. It's confidential. We're not going to retaliate against you. The more you have that stuff in writing and the more it looks like you actually have a process to handle these things, the better off you'll be later. If you have to defend one of these claims or, help your employee out, you want to be able to walk them through where that happens. And a handbook is where you could outline those things. Then there's policies. Policies are things, that mostly do go in the handbook. Sometimes things change, things need to be updated. So often you can just do a memo to your staff that says, regarding policy change of, I don't know, maybe like how you clock in every day. Okay, instead of doing this, we want you to do Y instead of Z. You could be sending people policy updates. You got to be careful about changing material terms of someone's employment once they're working for you. And what I mean by that is often people will hire employees and they'll get a year or two down the line and they'll talk to me or another lawyer and be like, oh, I don't have a non-compete in place with these people. I don't have a non-disclosure agreement. Can we do that now? The answer to that is yes, but you're likely materially changing the conditions upon which they agreed to work for you, meaning now you can't just have them sign a piece of paper without giving them something in return for it. And that something often has to be something of pretty decent value, like a raise, a significant bonus, a promotion. So you got to be careful in implementing. There's just operational policies, which is fine. And then there's like these legal things like the non-compete, non-disclosure that, you got to talk to counsel about whether you can just do that midway through someone's employment with you. And then the offer letter. We already talked about the offer letter, how that's appropriate if you don't have a handbook yet. Even if you do have a handbook, you should still be giving people offer letters when you hire them, because that's at least going to set forth what their deal is with you, the employer, meaning what are you paying them? What is their job? What are some basic responsibilities you're expecting them to adhere to? What are the benefits, the working hours, whether it's remote or in person, things like that. So the offer letter is where those things are going to live. And then usually when you have employees, you're going to hire a payroll company to pay them. A lot of people will run payroll through one of those online things. I don't always recommend those. If you have a problem, it's very difficult to speak with someone. If you have employees in multiple states, you got to be sure that these people know what they're doing in terms of the accounts they're opening and who they're paying. If you hire a payroll company, they will take care of all that initial government paperwork, like the W-2 and I-9. They'll get direct deposit set up, and they'll generally handle your employer tax payments for you. Some people, again, they process their own payroll using QuickBooks even. You got to really consider whether it's worth the liability of doing that or whether that's worth paying, a few bucks a month to have a payroll company handle that for you to make sure those payroll taxes are appropriately handled. All right, finally, COVID. All right, so COVID obviously is a really big thing right now. One is the vaccinations. We're publishing some information on our website and some YouTube videos about this. The short answer is yes, you can require your employees to be vaccinated. Now, what you have to be careful of is, number one, your employees that might have a legitimate medical reason why they cannot or do not want to be vaccinated. You don't want to inquire too much into that. If your employee says, I can't be vaccinated for medical reasons, you might want to talk to an attorney about whether it's just best to leave it at that. Because again, you're kind of wading into that. This is a potential ADA discrimination claim. If that employee tells you they have a medical reason to not get vaccinated. Otherwise, I would have a policy, around that. We're going to publish some on our website, some potential legal language you can use for that. So if you need any more information, just reach out. We'll get that to you, the link. Safety, then there's just like the safety of your employees. A lot of employees are still saying, now that these mask mandates are starting to lift, well, that's great, but I still don't want to go to work. I still want to wear a mask. I want to make sure that anyone you're bringing from the public into this business is wearing a mask. And you have to weigh the costs and benefits to that and whether that's, worth it to you. Also, if your employee tells you, hey, I'm immunocompromised, I'm going to have to keep wearing a mask, and I only want you to have me interface with members of the public wearing a mask, you might have to accommodate that. Again, going back to the ADA claims, is that person telling you they have a medical issue that you need to accommodate? So whenever an employee is telling you about a medical condition and that there's a reason they need something done for them, your spidey senses should go up and immediately say, okay, this person, they've told me about a medical condition. Do I have to accommodate this? What do I do? And then that's a really good time to speak with legal counsel. So COVID right now in employment, there's a lot of things you want to be thinking about. Policies, vaccination policy. Are you going to have one? What's it going to say? Who has to be vaccinated? Are you going to inquire to see their card? Again, we'll publish some language for you on our website in a video. And again, the safety aspect of it. Do your employees feel safe? Members of the public, do they feel safe? And what do you want to do about that? All right, finally, here is our contact information. If you have questions about employment agreements, do you have the right documents in place? Do you need some new things? Do you want to talk about COVID issues, ADA claims, things like that? Feel free to reach out to our office. Here's our phone number, the 215-482-0285. And then there's the info@phillysmallbusinesslawyer.com as our email. Thanks for joining us today, though. I'm going to stop sharing here and stop the recording.